I now take this opportunity to introduce the esteemed panel and the moderator for the day. Firstly, I would like to introduce Mrs. Shiranti Gunawardena, Attorney at Law. Mrs. Shiranti Gunawardena enrolled as an attorney at law on 12 December 1975. She started her career as a legal officer of People's Bank. Thereafter, she served as the Deputy General Manager Legal at the Mercantile Credit Limited. She was an advisor to all the Mercantile group of companies. Then she set up her own practice in 1991 and became a partner of Shiranti Gunawardena Associates. Currently, Mrs. Gunawardena is serving as a consultant to Finance House Association, where all duly licensed finance companies are members. Also, she is the chairperson of the Bar Association Notarial Committee. Secondly, I would like to introduce Mr. Gigi Arul Pragasan, Attorney at Law. Mr. Gigi Arul Pragasan achieved first-class honors in all 3 years in his law exams in Law College, and in the final year, he topped the batch. Mr. Arul Pragasan is a proud receiver of Sir Lalita Rajapaksa Award for the Best Outstanding Student of his law exams, A.B. Kure Memorial Prize for the subject of Civil Procedure and Pleadings, the First Class Scholarship for Most Distinguished Student of the Law College for the final year, the Challenge Shield Cup for his outstanding academic performance. In the year 1979, he was unanimously elected as the president of the Law College Christian Federation, and in the same year, he contested and was elected as a junior treasurer of the Law Students Union. Mr. Gigi Arul Pragasan enrolled as an attorney at law in the Supreme Court of Democratic Socialist Republic of Sri Lanka on 26 September 1980. He is a life member of Sri Lanka Bar Association and Colombo Law Society. He is a member of the International Bar Association. From the year 1980 up to 1984, he conducted lectures for the final year students of Sri Lanka Law College, and a number of students who studied under him are now holding positions at the apex course. Mr. Arul Pragasan is in active practice for 4 decades and performing his professional career as an instructing attorney as well as a counsel. He represented in many sensational cases. Among them, some are namely in the early years of 1980s, the famous case known as Hotel Galaxy versus Mercantile Credit, always cited in regard to interim injunction. In that case, he appeared as a junior counsel to Dr. Colvin R. De Silva, and he also another well-known customary marriage case, namely Gracia Catherine Vijay Gunawardena versus Vijay Gunawardena. In this, he appeared as a junior counsel to Mr. Jacqueline Seneviratna, attorney at law, against Dr. Colvin R. De Silva. In recent past cases, namely when Sunday Leader newspaper was banned by then President Mrs. Chandrika Bandaranaike Kumaratunga, Mr. Arul Pragasan appeared for Sunday Leader newspaper in fundamental rights cases and succeeded. In addition to the above, he was involved in a number of public interest litigations. Namely, he appeared for Nalanda Ram incumbent Revenable Kinyawala Palita to reduce the petrol price and also against Air Lanka privatization. He also represented the Sri Lanka Bar Association in several cases. He also appeared recently in few sensational cases. Some of them are Z-score cases. He appeared for well over 1,500 students. And Mana Courthouse stoning case, he appeared for the Mana District Judge against the Cabinet Minister Rishad Baduddin. He handled Dr. Samita Samanmali's case, who has sued BMICH for the incident took place at BMICH few years ago and got a judgment of rupees 180 million together with 5 years legal interest. This is a landmark judgment in regard to damages cases. Now he's handling Mrs. Achala Priyadarshini's case, who is a lawyer and whose left arm was amputated above the elbow due to negligence of the doctors and staff of Mathura General Hospital. He was appointed as a member of the Law Commission of Sri Lanka by His Excellency the President on 24th of March 2015. He was also appointed by His Lordship, the Chief Justice, as a member of the Disciplinary Committee to inquire into the complaints made against lawyers, and presently he has been appointed as overall chairman of the Professional Purposes Committee appointed by the Bar Association of Sri Lanka. And His Lordship, Honorable Chief Justice, appointed him as the chairman of the disciplinary panel to inquire into the conduct of the lawyers. He was appointed by the Minister of Justice as a member of Civil Procedure Code Amendment Committee, headed by His Lordship former Justice Priyasad Dutt, President's Counsel, and presently headed by His Lordship Justice Priyantha Jayawardena, President's Counsel. Honorable Minister of Justice, Mr. Ali Sabri, President's Counsel, has recently appointed Mr. G.G.R. Pragasa as a chairman of the advisory committee to look into the amendments to various ordinances and acts, more particularly to review Notaries Ordinance, Power of Attorneys Ordinance, Wills Ordinance, Registration of Documents Ordinance, and Revocation of Irrevocable Deeds of Gift on the ground of Gross Ingratitude Act No. 5 of 2017. Thirdly, I would like to introduce Mr. Felician Fernando Pulle, Attorney at Law. Mr. Felician Fernando Pulle passed out in 1983 from the Law College and having a civil practice of 38 years. He formed the only outstation website, www.nigambolawsociety.com, running for the last 20 plus years. Initiated the email group NLS E-Team discussing various legal matters among members. Currently serving as the chairman of Bar Association of Sri Lanka Law Reports Committee, which is instrumental in launching BASL e-report. Mr. Fernando Pulle is also serving as a member in the Civil Law Reforms Committee appointed by the Ministry of Justice. So, the moderator for the day is Mrs. Nirodha Kalansurya, Attorney at Law. Mrs. Nirodha Kalansurya holds a Bachelor of Laws from Open City of Sri Lanka, Master of Laws from University of Colombo, and she is currently reading for a PhD in Science and Management University in Malaysia. She also holds a post-attorney diploma in banking, finance, and insurance. She is an attorney at law, notary public. Also, she was the convener of advisory committee to Minister of Justice for law reform related to conveyancing appointed by Minister of Justice. She is a visiting lecturer at Sri Lanka Law College and Central Bank of Sri Lanka. She has released several publications, research papers, and articles related to conveyancing and law of banking. So members join this session by Zoom may send in their questions through the Q&A chat box to reach the moderator. I will now hand over the proceedings to the moderator. Over to you, madam.
Thank you, Adisha. Good evening to everyone. Notaries Ordinance number 1 of 1907, which we are going to discuss today, is a very archaic piece of legislation, which is enacted more than 100 years ago. Notaries Ordinance is amended recently in 2011 and 2013, but only for very minor matters. So when you consider about execution of deeds, mainly deeds of transfers, we all have noticed that there is a rapid increasement of fraudulent transactions, and the provisions in the Notaries Ordinance are not adequate to safeguard the notaries as well as the bona fide purchasers. So this issue was very correctly identified by the former Minister of Justice, Mr. M.U.M. Ali Sabri, President's Counsel, and has appointed a committee making Mr. G.G. Arul Pragasam, Senior Attorney at Law, as the chairperson of the committee and comprising of few eminent lawyers to review the Notaries Ordinance and to propose suggestions. So it is a great failure if I do not mention about our dynamic chairperson, Mr. Arul Pragasam, Attorney at Law. Arul Pragasam, sir, at this moment, who was the main energetic person behind this huge mission. So we shall be very grateful to sir because without his commitment, these amendments wouldn't have been possible. So it was a challenging task for me and for all the committee members to work with sir as he needs work perfectly and on time without excuses, though we all were busy with our own schedules. So we also had limited time as we were given a deadline to finalize this task by the Ministry of Justice. So we all had to work from early morning till late evening on every Saturday and Sunday to meet the deadline and work tirelessly to achieve the task. So sometimes we met even on weekdays just after courts. I would say all the meetings, including inauguration, were sponsored by Sir in luxurious hotels sometime, most of the times, and all the facilities were provided out of his pocket. So we all came for the meetings with great enthusiasm, and sometimes we forgot our main purpose because we all were learning law from Sir, and it was like a lecture room at Law College. Thank you, sir. We all learned a lot from you, and thank you very much for your all hard work. Today, we are here to discuss the new provisions introduced to Notaries Ordinance. And as I can see, the amendments that are proposed is a great achievement for all the notaries, lawyers, and the purchasers, and it strengthened the land transactions as well. I would like to pose the first question to Arul Pragasam, sir. So my question comprises several sub-questions. So the first question is that according to the prevailing laws, after taking oaths as a lawyer, anyone can apply to get notary license to become a notary. Notary's ordinance is well over 100 years of old document, and the qualifications to become a notary, which prevails, are introduced 100 years ago. Sir, is that still continuing? Is my first question to you. So the second question is, according to the proposed amendments, are there any restrictions to become a notary, or are there any prerequisites that has to be fulfilled by a newly passed out lawyer to become a notary? And if that is so, kindly explain us, sir, as to why those restrictions are imposed. Thirdly, also explain us, sir, can only lawyers become a notary, or can any other person become a notary? Over to you, sir.
Yeah. Good evening to all of you. Thank you, Adisha, and special thanks to Nirodha for your kind introduction. Nirodha, before I answer your series of questions, I wish to recognize our hardworking team who assisted me to go through this process of finalizing the proposed amendment to the Notaries Ordinance as well as to other ordinances. Notaries Ordinance in existence far back from 1907. Last 115 years, the Notaries Amendments have been amended many occasions. As quite correctly pointed out by Nirodha, very often the amendments are based on a particular section or a particular area or a particular clause. This is the first time after the period of 115 years, the legislation thought to visit the entire Notaries Ordinance and to propose amendments. In this regard, I must give the full credit to the former Minister of Justice, present Minister of Foreign Affairs, MUM Ali Shabri, appointing me as a chairman of the committee, and also special thanks to my able team, because I was fully guided and assisted by our ever vibrant Sharanti Gunawardana, as well as all-rounder our Felician Fernandipille, and well dynamic and enthusiastic and charming Nirodha Kalansurya. And in addition to these members, I also got the assistance from many other members. I'll just give the few names just to give them express my gratitude. Mrs. Fatima Thalesingham from Legal Draftsman, Mrs. L.G. Puncheva from Legal Draftsman, Chatrika Vijay Senior Attorney at Law, Mrs. J.K.C. Jagodarachi, Senior Deputy Registrar General, Mrs. H.N.B. Herat, Deputy Registrar of Lands Candy, Mrs. Rismi Firdaus, Senior Attorney from Attorney General's Department, Mr. Lasita Kanwonarachi, Attorney at Law for Minister of Justice, Mr. Chamath Fernando, Attorney at Law for Minister of Justice, Mr. Sanjeev Dasanayaka, Attorney at Law for Minister of Justice, Mr. Samantha Vitana, Attorney at Law, Ms. Indika Nagaratna from Attorney at Law from Matharaba, and Ms. E.M.P. Kumari Aberatna, Attorney at Law from Kandipa. So now these ordinances have been already approved by the Cabinet and sanctioned by the Honorable Attorney General Department, And now it's only to be present in Parliament to become the law of the land. Now, Nirodha, let me answer your question. I think your question is series of questions. First question is whether with the prevailing law, what is the position and what are the amendments made in regard to the becoming a notary public. As at section 3 of the Notaries Ordinance, prevailing law is when you pass out as an attorney at law, if you have got through your conveyancing paper, you can make an application to the Minister of Justice earlier. Now it is the Home Affairs Minister to obtain your notarial license. When you make an application in terms of section 3, in terms of section 4A, presently Home Affairs Minister will grant the license for you to practice. And it will specify in what area, what zone, judicial zone, or what district that you can practice as a notary. In addition to that, in terms of section 5, the minister will specify in what language, depending on what language you go through your conveyancing paper, whether it's English or Tamil. So you will get the license to practice. The other question that you posed was whether, in addition to the lawyers, any other person can apply to become a notary public. Yes. In terms of section 4, subparagraph 3 of the Notaries Ordinance, if any notary's clerk work under a notary, and if he gain experience, then he can, with the certificate obtained from the relevant senior notary, he can make an application. He can sit for the conveyancing paper in Sri Lanka Law College. If you get through the exam, he also could, not only lawyers, even a notarial clerk could practice as a notary. Now, once you become a notary public, you are duty bound and obliged to adhere to the Notaries Ordinance, and more particularly, section 31, subparagraph 1 to subparagraph 36 of the Notaries Ordinance. The Notaries Ordinance, section 31, subparagraph 1 to subparagraph 36 specifically spells out as a notary what and what things that you should do and what are the things that you should not do. If you fail to do what you're supposed to do, or if you do indulge in the activities that you're not supposed to do, you have to face far-reaching consequences. If any clients complain against you to the Supreme Court in regard to a professional misconduct, after inquiry by the Supreme Court, in the first instance, may suspend the license or cancel the license. In terms of section 39, subparagraph G of the Notaries Ordinance, in addition to cancelling the license, you may have to face a rigorous or a simple imprisonment for a period of not more than 5 years. I'm the overall chairman of the Professional Purposes Committee. For a week, I received well over 10 complaints. Out of the 10 complaints, 5 complaints are against newly passed out notaries. And reason A, ignorant of the law. There are malpractices too. So main ignorance is based on section 31, subparagraph 1 to 36. So that is the very reason as a committee, we all decided to introduce a new method, because the method that prevailed earlier was no sooner you pass out as a lawyer, you can straight away apply for your notarial license without any kind of experience. Because what is happening today, newly passed out lawyers who are obtaining their notarial license, engaging a notarial clerk, not stepping into the land registry, just collecting a quick buck and putting the lobby mark. To avoid that, and to people, you have to understand, when a person coming and entrust in a deed to you, that may be his entire hard-earned life saving. So you have to be cautious. So now that is the very reason now we have introduced in section 3, it categorically states what qualification that you should do. Number 1, you have to, after you pass out as a lawyer, you have to go through minimum 1-year program under a senior notary. That particular notary has to complete at least 10 years in the bar. So basically, the prerequisite or the requirement is A, upon you passing out, upon you got through your conveyancing paper, you have to go through a 1-year training, and that particular training should be a lawyer who is not less than 10 years in practice. Upon you obtaining a certificate from the senior attorney at law, and together with your conveyancing paper, you can tender to the Home Affairs Minister to get your license. So answer to your question in various things. Nirodha, number 1, the earlier no sooner this particular piece of legislation will become the law, you can't just automatically become a notary upon getting your attorney's at law certificate. You have to go through 1 year period training the senior who has completed at least 10 years in the bar. That's one. The second question that you pose, can any other person become a notary public? Answer is yes. In terms of section 3, subparagraph A, a notary's clerk who work under a senior notary, having completed 2 years, can sit for the conveyancing paper, and thereafter he can become a notary public. That's the answer to your question, Nikonda.
Thank you very much, sir. Madam, as notaries, we are facing many problems when we carry out our duties. A huge responsibility is cast on notaries, and sometimes it is very difficult to strike the balance between complying with laws and the practicality of the scenario. When proposing amendments, committee has not only gone through the Notaries Ordinance but also studied other connected laws and the practical problems that are faced by notaries. Madam, what are the practical problems that are faced by notaries when they comply with the existing Notaries Ordinance, and what are the measures that have been taken to safeguard notaries with the proposed amendments? Over to you.
Thank you, Nirodha. Your questions are very appropriate. First and foremost, I would like to tell you that it was a pleasure participating in the committee headed by my dear friend, Mr. Arul Prakash. So he was there always for us, and it was our second home. He looked after everyone. He made us work very hard. And not only that, even despite the COVID, he made us work very, very hard. But he looked after us. He provided everything: stationery, food, and the knowledge for all of us. We have to appreciate all the other members also who came in from far and helped us to do this. This was a great job which was done, as you are very well aware, as very correctly Mr. Arun Prakasan pointed out. This has been pointed out even by the Attorney General, that there are many complaints against notaries. Therefore, when we made these amendments, we all took it to our heart that we should protect the lawyers. Now, number one, there is always the allegation, even when we go to courts, when the mortgage bond is contested. Number one is they obtain the signature of blank papers. That's always an issue that comes in court. Now, as you are well aware, Rule 31 is like the Bible to us. Rule 31, you have to be very, very well conversant with Rule 31 before you become a notary. And Rule 31, whatever the very, very important section which should protect the lawyer, was very well amended, and the able patronage and chairmanship of Mr. Arul Prakasam and all the other seniors and juniors. Now, number 31, rule number 3 says not to obtain signatures on a blank paper unless completed. Yeah, this has brought in a very good amendment where people, as I know very well, most of the people do what they do is when customers come, they give them some blank papers, they tell them to sign and go. Only 2, 3, 4 days later, only they type the deed. So that practice has been done away with, and I think it's a very good rule, and the lawyers should follow it. Then comes section 31, rule 7, payment of stamp fees. There are many cases where stamp has not been paid, or stamp fees have been paid by, I'm not putting the blame on all the notice, but there are many cases. In fact, I was told there was a notarial clerk who had paid out so many people. One notary practicing in town would have to pay 3,700,000 as stamp duty. And ultimately, the girl the notarial clerk who played out the stamp duty has killed herself. So we need not go to that far when we look at the very popular amendment done by the Notarial Committee. Section 30, Rule 7 says payment of stamp fees, and also it has specifically states that the stamp fees when it's paid, the receipt issued by the authority, the bank, it should generally be what we do is we only paste it on the duplicate. But now it has been made mandatory for you to paste one protocol and nothing the original. So that will really save all of us and save the customer as well as the notary, because we have done the correct thing by doing so. Then a third part, who has many deeds executed by companies. When a deed is executed by the company, so we have been all told to call for the certificate of incorporation. We have been called to look at the we have been told to look at the form 48 or the form 20 as the case may be. Then sometimes when you make a search on a deed, you have to go round and round the mulberry bush looking for the certificate of incorporation, looking for the resolution. But now, as you are well aware, in the amendment, it has a board resolution to be obtained, comments place before signing, and a copy of the board resolution be retained by the notary. It's a very, very good suggestion. Then comes at 3115. 3115, again, new section has been included with respect to the power of attorney. You know, there are many transactions that take place by power of attorney. And once the power of attorney is done, once the deed is executed, there are many instances where the next day the power of attorney is revoked. Because there's nothing called irrevocable power of attorneys. Power of attorney is always revocable. There are people who play out, banks and finance companies, in this manner. Therefore, this is a very important section. It says to obtain an affidavit from the executant acting or signing by a power of attorney, certify that the power of attorney has been forced and has not been revoked, and it has to be attached your deed. I think that's a very good suggestion. Then we should go to section 16, rule 3116, as very correctly pointed out, all the practicing lawyers has stated that condemonium property, the unit and the number to be enclosed are well aware. Nirodha pointed out, and Mr. Abhikasaman pointed out, this is a very old piece of legislation. At that time, they were not thinking of skyrisers and condemonium. So the Notaries Committee has brought into this, recognized about the condominium property and how it should be done. In addition, there are so many other important new sections which have been introduced. Number one, there are many plots that take place in the land registry. Land registry is the worst place, but it's a worst enemy of notary. There are many cases. There's a we have to obtain a certified copy of the extract from the relevant land registry. Then it says that we should, at least under Rule 17, that we should always place the prior registration in the deed. It is not properly connected. We lose the priority conferred by Section 7 of the registration law. That this is one of the, I think this is very, it was widely discussed before we arrived at this, where we says that in a case of a transfer deed of gift or deed of exchange, that it is mandatory that we should always have a photograph of the passport size attached to it, and also we should attach to a protocol a copy of the national identity card, the passport, or the driving license. Then it comes in the when you are executing. This is also very important, because sometimes you go round and round the mulberry bush if you want to do a duplicate search. But by putting this amendment, we have said all the details, including telephone number, his office address, and if he is working, that's a very good. How if he is working as a officer in some organization, he should put that also address also in the deed. Then also we have the other one we have included is if it is if you're attesting a deed, we must always keep a copy of the certificate of incorporation and the directors list in with us. The last one, even about this also looking into so many angles. The rules when amending the trust deed, they have looked at how if a title comes through a trust deed, what are the duties of notary, and how in the attestation, how what we should include. We should include the names of the trustees and what are the specific powers that have given to them. I think this piece of legislation which was done by all of us, and thanks to, as very correctly pointed out, Mr. Ali Shapri, who was there, and also I must give the full credit to Mr. Arul Prakasam for finishing with this within the specified time period. We are the only committee that completed it within the period, time, and due to the drive you made, and I should thank you, especially I think your name should go down in history when this piece of legislation come out, because you have done a great job. Not only all the other committee members, including Nirodha, Pidishan, Ms. Abhiratna, Martha, everyone has done. But special thanks to you, because you were there like a rock, driving us like an elephant, getting us to work. So this piece of legislature was specially done, taking into consideration not only the clients, you always we thought of our brother and sister lawyers whom we should protect. Thank you very much.
Thank you very much, Madam. Mr. Felician Fernando Velez, sir, we have seen many clients are complaining against notaries, saying that they were asked to sign on blank papers, and sometimes they say that they were unaware of the content of the deed they signed. They make complaint against notaries, saying that it was not explained to them. Some clients say that required stamp duty was handed over to the notary in cash, but the stamp duty has not been paid or paid in cash. This matter was endorsed by Arul Pragasam sir. Correct, because he said that the Bar Association is getting so much of complaints. Sir, what are the features introduced by the proposed amendments to the Notaries Ordinance to safeguard clients from the notaries who indulge in malpractices? Over to you, sir.
Good evening. Thank you, Nirodha, for your kind introduction. And before answering your question, I must thank Ms. Arul Pragasam, our chairperson of our committee. I endorse what Mrs. Gunawardhan and Nirodha said about your guidance and leadership. I don't want to take much time on those things. I fully endorse what they have said. Thank you, Ms. Arul Pragasam. Before going further, I must make one correction in the bill. What Mr. Arul Prakasam has said, clause 2, if you go through the bill, it says the statement of legal effect, it says 10 years of consecutive practice as a notary before issuing a certificate. That's wrong. That statement of legal effect is misguiding. It's only 1 year of consecutive practice as a notary before issuing a certificate. An attorney at law should have 1 year's practice, not a 10 years practice. So you can see it on the second page of the bill, or rather the first page of the bill. That's a mistake. Having said that, I must say this committee, when we were entrusted in for the task of formulating the amendments, what we have done is we have made the amendments based on the good notarial practice throughout the country. So we have taken from notaries who have taken very good care of their clients and have adhered to very good notarial practice. We have taken those good practices and put into legislation. So in answering Nirodha's question, there are several ways we have safeguarded the rights of the clients under this amendment. Firstly, I must say under section 3, thorough training of a notary before practicing, before issuing a notary license. 1 year's thorough practice is required under the new amendment. if you see, the conveyancing is the most practical subject taught at the law college. But unfortunately, law students take very little interest in it, and therefore they are deprived of valuable opportunity of learning the art of drafting. So once they become notaries, they find they in a very difficult situation where they find it in draft and not training proper time, recommending title, they'll find it very difficult. To overcome this defect, we have proposed that before issuing a notarial license to anyone, any attorney, he should have practice of 1 year lawyer, a practice of 10 years of notarial, so that this then Nirodha 58(1)(a) of the amendment ensure practicing notaries have submitted duplicates for the previous year obtaining the warrant. We have seen in many instances, some notaries are not submitting the duplicates to the relevant land registry in due time or not submitting at all. But still they continue to be practicing as notaries and misleading the clients. So to avoid that, there should be they should submit an affidavit to say that they have the proper duplicates in time to the proper land registry. Then section 3115A ensures the validity of a power of attorney is checked and verified. Before attesting a deed which involves a power of attorney holder, the notary should check the validity of the power of attorney. Then section 31(7)(a) imposes the payment of stamp duty, entrusts the payment of stamp duty to the notary. This eliminates the non-payment of stamp duty. Also, section 3130 provides registered powers of attorney to be attached to all copies. Currently, there is no provision that the power of attorney should be a copy of power of attorney should be attached to the original or to the duplicate. So, this new sub amendment empowers the power of the registered power of attorney to be attached to all copies, original, duplicate, and the protocols. Section 3117 provides the window details to be added to the deed. In addition to that, photograph and national ID card copy or the passport or the driving license copy to be obtained and retained by the notary. Then section 31, subsection 30A, it has made mandatory the registration of deeds. You must be knowing that under the notice ordinance or the registration of documents ordinance, registration of deeds is not mandatory. But we have made it mandatory because the issue of prior registration will become minimized by this introduction. Then section 31, subsection 16 requires the obtaining of extracts prior to dealing with immovable properties. This will eliminate the forgeries and later alterations. Section 3120 requires the details of notary to incorporate in the deed the details of the parties with the NIC numbers and copies of the NICs and obtaining a photograph in the original. And also section 4 and many sections has enhanced the fines and charges. Normally some of the fines are very minimum amounts imposed 115 years ago, but we have increased. We have suggested that those fines should be increased. And section 20, it says the previous ordinance says if convicted, he shall become disqualified if the subject minister is of the opinion of disqualification. But here, after the amendment, there is no option for the minister to decide. He is automatically disqualified if he is convicted. Also, section 31, subsection 20A of the amendment provides the consideration details to be incorporated in the attestation. That is the amount paid, whether it's paid by bank pay order or a check, or in whose name the amount was drawn, what the amount, and all those details to be incorporated in the attestation. These are the salient features incorporated in the amendment to safeguard the rights of the parties. I think I have answered the question for that.
Thank you very much, sir. Arul Prakasam, sir, what are the, I know that we have proposed several suggestions to the Notaries Ordinance, and almost all the suggestions are very salient. Sir, but tell me, what are the most salient features that you have proposed as amendments to the Notaries Ordinance?
Before I answer you, Nirodha, first of all, I must thank Shiranti as well as Felician for the kind words that they said about me. Thank you. Felician, just to correct yourself, I think if you look at paragraph 3, I think there is obviously a typo. The meaning is there. It says, every attorney at law who has passed the examination conducted by the Council of Legal Education in conveyancing after his admission, such attorney at law who has obtained a certificate substantial in Form B1 set out in the second schedule hereto from an attorney at law who has been in active practice as a notary public consecutively period of 10 years. I think it should stop with that. But I think they are mixed up more than the law. I think there's some wrong in English. Just for the clarity, I will again repeat it. In terms, once this piece of legislation passed, to obtain a notary license, the qualification will be a lawyer, the attorney at law who has newly passed out has to work under a senior for a period of 1 year and must obtain a certificate. As Felician said, I to end off, there is certain typographical errors there. Now, answer to your question, Nirodha, the salient, there are quite a lot of salient features have been already set out by Shiranti as well as Felician. I will deal with some other section. I think the most crucial section is section 31, subparagraph 9. As you know, in the main function of a notary public is executing the deed. The person who is coming to execute the deed is the, now say for example, if it is a deed of transfer, it is a buyer. So when the buyer comes to us, the person who is selling is the executor. So invariably, we don't know the seller. We don't know the seller. We know the buyer. So practically what's happened because of this clause in section 31, subparagraph 9, which I read the whole one, he shall not authenticate, attest any deed or instrument unless the person executing the same is known to him or at least the 2 witnesses. So as at now, the law stands for you to execute a deed, either you should know the executor or you should know the 2 witnesses. Otherwise, witnesses should know the executor. So practically what's happening is, as I said, our client is the buyer, but he is not the executant. So because our client is the buyer and he is not the executor, to get out of the problem, what we do invariably, either we get our court clerk, peon, or a driver to sign as a witness. Having we got him to sign as a witness, what we say in attestation, the executor not known to me, known to the witnesses. Now, if something goes wrong, in the event of any impersonation, who gets into difficulty? The poor driver, clerk, or the peer, not you. So to avoid that only, we have now brought in the new section 31, subparagraph 9. There again, as Felician pointed out in 31 paragraph 3, here again, there is an error. The proposed amendment, what we said is, one of the parties, we didn't use the word executor, one of the parties. So the new amendment says, he shall not authenticate or attest any deed, instrument, unless it should be one of the executor. It says, or one of the executor is known to the party. So the proposed amendment is to get out of this 31(9) problem. We say you should know one of the parties. In regard to this, Nirodha, I can give you an example. Recently, a senior lawyer who has completed 50 years in the bar was indicted. The reason was he executed a deed. In the deed, he got his son as well as the driver to sign as witnesses. The deed was challenged. And now the notary has been indicted, the driver has been indicted, son has been indicted. He's a very senior lawyer who has even written books on conveyancing, and I don't want to mention the name, recently passed away. So this is the problem we have. So just to tell you, 31.9, we have proposed the amendment to get out of this practical problem. When you execute a deed, either you should know buyer or the seller, one of the two. So thereby, the practical problem that we do not know because if you don't know the seller, we can't tell seller to bring two witnesses and come because we don't know the seller. So to avoid that practical problem, now we have got it. Wording should come there is one of executor. That is one of the most salient features. Then the next is section 31, subparagraph 17. Because section 31, subparagraph 17 says, the earlier 17A, that before any deed or instrument other than a codicil or last will affecting any interest of land or other movable properties drawn by him shall search. So according to the old notaries ordinance which prevailed for last 115 years, it is mandatory before you do a search, before you go through a transaction, you have to do a search. When you do a search from the broad portfolios, cross references, or carried over, you will come across many encumbrances such as list pendant, caveat, seizure notice, mortgage bond, various things are there. Now, the section 17B, a new section has been introduced. What is the new section? He shall obtain from the registrar of land the relevant land registry certified extracts of the folio containing the last entry pertaining to such land movable or immovable. So the earlier law is what was mandatory to do a search that even our people don't do. Now you have to go a step further. Not only you have to do a search, before you execute the deed, you should have the extracts, registered extracts in the land in your hand before you do the transaction to see whether there are any encumbrances. That is one. Then the second amendment, what they have proposed is, in the case of a deed of transfer, deed of gift, or deed of exchange, shall affix the original such deed, instrument, passport size certified copy of the photograph, or to which the notary has affixed a seal, shall keep copies of the national identity card, passport, driving license attached. So it's not only do you have to do a search, number two, you have to get the extracts of the last entry. In addition to that, you have to have a photograph. It has to be certified, and like what we say, this is the signature of so and so. Like in addition to that, you have to get the either driving license, national identity card, or passport to ascertain, basically to avoid the impersonation. But there are so many people are coming impersonating in front of you. So now this will avoid a lot of malpractices. That is one. Then the second thing is, it says any part, I think Shiranti dealt with this issue. If a party to a deed of instrument is a corporate body or shall retain a certified copy of the certified incorporation, other instrument established there. So now, if the transaction is taking place or a seller is a limited liability company, then you have to look into what have you got to look into? You have to look at the memorandum and articles. Who is authorized to sign? If there will be a clause to say seal. How can you affix a seal? Is it two directors company or is it a one director company? Is it a director and a secretary should sign? Who should sign? For that, you have to get your form 15 to see the shareholder. Form 20, the directors and memorandum article. Because if it is a major transaction in terms of section 185 of the Companies Ordinance, Companies Act, you have to get the shareholders resolution because the property belonging to the shareholders of the company. So the shareholders resolution is needed. So the mandatory requirements now are, number one, search in any event it was there earlier. The new amendments are, addition to doing a search, you have to obtain the land registry extract, at least or specifically the last entry. Then if it's happened to be a deed of transfer, deed of gift, or a deed of exchange, you have to have the photograph certified by the notary. Addition to that, you also have to get the identification, national identity card, passport, or driving license. When you come to a limited liability company, I'm talking about the practical side of the matter, you have to look at the memorandum and article. Who is authorized to sign? So there. Now, say for example, if it is a deed of gift, whether such gift is permitted in terms of the act, or if it's a, say, in regard to charitable organization, whether they are entitled to receive. So those things have to be looked in. So then company section form 15, form 20, if it's a major transaction, okay. Then as Shiranti said quite correctly, back again 17D has been amended. In the case of a deed in relation to a trust, he shall state the name, address, and the national identity card of the trustee who are acting under the trust deed and section, all that is there. So that is in regard to section 17. Now I like to read this section 20, which has been only correct. I'll read the earlier ones and also I do the correct. This is the most crucial section. 31, section 20 is the attestation clause. Number 1, it says section 31, subparagraph 20, clause 1, that the said deed or instrument was signed by the party and witnesses thereto in his presence, in the presence of one another. Because you have to all the parties together. Otherwise, it's not a valid transaction in terms of that. There again, I could give a case which I handled. A particular person who did the deed of gift was admitted to a private hospital. A deed of gift was done, and after the gift, a few days later, the person passed away. The gift was challenged, and bed date ticket of the doctor shows very clearly from the date of the admission till the date of the death, this lady was in coma, never recovered. So now the notary has been charged and the witnesses have been charged. So that is the very reason it says very clearly, parties have to be together. Because especially very often, as Chiranti also pointed it out, getting this blank document, sometimes not even notary, notaries are present. Sometimes in front of a notary's clerk or a peer, they get blank signatures. Parties are not there. So they send a complaint to be saying that I signed blank signatures, I never saw the notary, I never saw anyone. So that's number 1. So in the attestation, you have to say. Number 2, in regard to the B, there is a amendment as coming. Whether the executant of the said deed or instrument are known to him, whether he has identified them by the inspection of the national identity card, bio page of the passport, driving license, whether the witness thereto are known to him, and the latter case, he shall specify the execution person knowledge or not. So in the attestation, generally we say, I, the undersigned so and so, we put out on such and such. Then you must say from the executant or the witnesses who are known to you. There, you have to give the detail, whether you knew the executant or whether you knew the witnesses. You have to say that. That's a new one has come. And also there, you have to specify and say holder of identity card number, holder of passport number, holder of driving license. How did you identify? So that has to be specified. Then back again, the most C, the day, month, and the year which the place where the said deed or instrument was executed, acknowledged, and the full name of the attested witness. Now, there again, I'll tell you, because there are a lot of complaints against lawyers, at times due to an error. There again, I can give you another example. A deed was executed by a particular party on a particular Friday. Having signed the deed, the person went abroad on the very same day. The deed was stamped on Monday. Then there was some dispute in regard to the consideration. The deed was challenged. What did this notary do? Deed was done Friday evening after the banking hours. So obviously, in the attestation, if a deed of that nature, you have to do 2 things. You first do the attestation and say, sign in front of me in the presence of such and such on that day, Friday. Then you have to say, I further certify and attest that the stamp duty to the said document was paid on such and such a day. Now, in this particular instance where the deed was challenged, what this person, notary, did, this young notary, instead of putting the Friday date, they put the Monday date. Monday was out of the country. Monday was out of the country. What is the result deposition? Deed set aside. Why? That is not the act and the deed of the person. He was not in the country. He produced passport, I was not here. So you have to be careful, because when you put attestation, if the deed was signed on a particular day, if the execution, if the stamp duty was going to be done on another day, you can put through both dates, because we are permitted in law to pay the stamp duty within a period of 7 days. So if the deed was done one day, you do the correct attestation. Then you say, I further certify and attest that the stamp duty was paid on such and such a day. So the earlier case, what I said was, in fact, it's his signature correctly done due to the error, the problem he faced, and Now there's a complaint against the notary. Then the third one is whether the same was read over by the person executed same and explain. Now there again, you have to explain and say, now is a person who is speaking Tamil or we can't understand English or Sinhala. What language that you explain, whether you did it. So all those details have to be given. Then the other thing is very often when you talk about read and explain, I have to say with responsibility, I myself has come across, especially when you go for banks to do with your clients to get the mortgage bond. I'm sure Shiranti as well as Nirodha and Phoenician all will endorse. How many bank legal officers will explain Section 47A declaration? They'll never explain. But in the Section 47A declaration, when you pledge the property, it is not the property that you pledge. Even your subsequent properties also caught up with. They never explain. They just smuggle in the document and get your signature. So that's wrong. You have to read over and explain to the party that you have to set up. Then the most crucial thing is now amended is Section 31, Subparagraph E. Now, whether the money was paid or not in his present, as this amendment to the consideration or part the consideration, it is if paid, actual amount, local currency. Now, there are instances where client come and say, sir or madam, money was paid. Can you say it was paid in your present? Don't do that. If no transaction take in front of you, say no consideration paid in my present. If the client says money was paid earlier, say that money said to be paid prior to the execution. A transaction which did not take place, don't ever say. Then you have to say, how was it paid? Is it by cash? Or is it by bank draft? Is it by a pay order? What is the way? And now, I think I've come across many young people are doing. In the attestation, what do? They put post-dated checks. We are not selling items in better market to put the post-dated checks. Post-dated checks are invalid. Those are not valuable consideration. The deed can be set aside on the basis there is no proper consideration. Consideration not part. So therefore, post-dated checks cannot be used. You have to be careful. Then other crucial thing is clause G, specifically the erasers, alteration, interpolation, which have been made in such deed or instrument, whether they have been made before the same was read over. Now there again, however senior you may be, there are instances, even any one of us can make mistakes in regard to something in the deed. It could be attestation, it could be some clause. If you have done any mistake, it's human nature. Don't do any juggler. Now there is a particular case where I'm handling the disciplinary matter. That particular case, a complaint against the notary was the according to the land registry obtain a certified copy of the duplicate. It says one thing. The original deed contains something, say some other thing. Now that particular complaint against the notary was that at the time of the execution of the deed, no, there was 10 million transaction, 10 million was not paid, supposed to be given later. Original deed says no consideration paid in my person. The duplicate copy, when you apply for a certified copy, it says entire amount was paid in cash in front of me. When the person was summoned for the inquiry and document was given, protocol is nothing. So don't ever do that kind of thing. If you have any problem, you made a mistake, you can take your original, you can take your protocol, go and meet the registrar of land, tell I made a mistake, can I correct it? They will bring the duplicate, whatever the land is, they'll bring the duplicate in front of you, do the correction in front of the registrar, and also in the attestation also do the same thing, you can correct it. So you have to be very careful at that kind of thing. So not to do any kind of erasers there. So there again, just to wind up, I'll say one more case, because I can talk about many cases, but I come across because of the fact that I'm the overall chairman. In another case, occasion, husband filed action against the husband. When husband and wife living together, husband gifted the property to the wife. Absolute, irrevocable, no problem, she was staying. Thereafter, husband filed action against the wife, summons was served. When the summons was served, she found in the documentation, the deed of gift has been cancelled and that has been re-gifted to somebody else. So when that person came to me, I said, look, according to this, that this particular deed has been cancelled and gifted to somebody. Was there any revocation clause? He said, no, sir. I applied for a duplicate from the land registry. According to the duplicate, it has been altered. Original is in the possession of my client, not altered, but the duplicate has been altered. So the entire case, the deed was set aside on the basis it's a fraudulent act. So back again, but I want to tell you three important sections. Number one, section 31, subparagraph 9, the most crucial amendment that we have brought in. Earlier law was you should know the executor. So in present law, there's an error, we have to correct it. The present law will be, it's not the executor, one of the parties to the deed. Then you are all right. Then the section 31, subparagraph 17, very categorically says that in terms of the old law, what you have to do is only a search. But in terms of the new law, in addition to the searching, you have to get certified extract from the land registry, number one. Number two, if you are executing a deed of transfer or a gift or exchange, then you must have the photograph of the person concerned, national ID, driving license, or the passport. That is very important. Then similarly, if the transaction is pertaining to your this limited liability company, you have to check the memorandum and article. Addition to that, Form 15 in regard to the shareholders' details, and also Form 20 about the director. Addition to that, you also must keep the shareholders' resolution as well as the director's resolution together with the deed. Then finally, in regard to 31, paragraph 20, what they say is more particularly when it comes to a question of consideration, you have to specifically set out how the money was paid, whether it was paid in cash, whether it is in front of you, whether it is what the methodology of payment. Thank you, Nirodha.
Thank you very much, sir, for your detailed explanation and the practical problem and the practical experience that you have shared with us. Endorses the fact that how important the proposed amendments are to make the life easier of the notary. Madam Shilanti Gunadara, Madam, what are the important provisions? Now, sir has explained the provisions which are salient features of the proposed amendments. What is your opinion as the important provisions that you have noticed in the proposed amendments to the ordinance? Over to you, Madam.
Rhoda, I think Mr. Abid Kasim has gone through in detail of all the mandate provisions and notary. If you have to be a good, honest notary, you should follow this. Now, there is a very good amendment made here with respect to last. As you are well aware, it's a disgrace to say most of our notaries play around, law and notaries especially, play around with the last will number. It has become, there was one case, there was a case which came up in the Commercial High Court. There was a certain sum was awarded in that case. That lady died. Then to see, they went and filed a district court case in Balapiti. Then this lady has left a last will. And when, as you are well aware, under the earlier notary's ordinance, when you write a last will, you have only to put the number and the date. So when you look at the number of the date, it is a separate document. The last will original is given to the testator or to someone nominated. You keep your duplicate copy with you. That's all. There are only two. There is no three protocol copies. So what happened in this case was, they went to Balapitiya, filed a testament case. I was smart enough. I applied for the note. I applied for the monthly list of this last week. That notary has not attested anything. Then I went with that, and ultimately they withdrew their application. To see the proxy in the court was filed by the wife. It is the husband who practiced some other province who has said this. There was a last will, so there was no such last will. They withdrew the case, so that was the end of the story. In this notary's amendment, we have introduced under Rule 20 that in the case of a last will, there should be the day, the name, the day, the number, and specifically the name of the testator. I think that's one of the greatest amendments that we have done for the benefit of the lawyer as well as for the benefit of the client. Because there are so many cases as a experienced lawyer, both Mr. Pananpuli and Mr. Abdul Prakasham will know that there are many testamentary cases where last wills are concerned which are being contested in court of law. So by doing this, we can cut down on that sort of unnecessary litigation, and it may create a trust on the lawyer, and the lawyer will also act, the notary will also act in a more honorable manner when you know you can't play around with numbers. Then comes the second most important thing is where registration has become mandatory. Mr. Fernando also pointed out, as you are well aware, Section 7 gives registration of documents or gives priority. So the priority rule applies sometimes in contesting deeds if it comes from the same source on the deed gender prior to the land registry. There are many cases where certain unscrupulous clients write on the same day, there are about 3 or 4 deeds written on the same property. And for instance, the fact that the notice committee has introduced this section where it says after Rule 30, where you have to register the deed, is a very, very strong point, both for the lawyer and the client. If we do not do that, that shows the malpractice on our part. I feel that these are 2 sections which have been introduced, which will turn around the law and the litigation and also protect the notaries. Therefore, I think we should, as Mr. Arul Prakasham correctly said, the notary must take no cognizance of all the amendments and go through it and read it and strictly follow. Then we will have no issues with our notaries practice. Also, the third one, the weekly list. I know most of us don't practice it at all. I can remember the good old days in 75, 76. Every Wednesday, I used to send my weekly list when I was in Niagara. Now we don't do that. We have done away. In a way, it was a checkpoint, but with this time and because we have done away with the weekly list, it's good for us. We have only to send the monthly list, and the monthly list also, I will regret to say that most of the notaries don't give their monthly list in time. Then we have a time looking for these things. We should strictly follow all these, and we must always make a point in our diary and in our notes to follow all these notes. Then life will be much more convenient for notaries. And then the act which was done under recommendations of Mr. Ali Chabri, present Minister of Foreign Affairs, and under chairmanship of Mr. Arul Prakasham, who gave me 100% practice, forgetting his practice, forgetting his work to do this, and all the committee members who have done so much for this. It will be quite a successful act, which will help both the notary and the general public. Thank you.
Thank you very much, Madam, for your explanation. Felician Fernandopoulos, sir, we have listened to Arul Prakasham, sir, as well as Madam Shantikul. Apart from what Arul Prakasham, sir, and Madam has pointed out, what are the other salient features you have identified in the proposed amendments to the Notaries Ordinance? Over to you, sir. Sir? I think you're muted. So I think you're muted.
Sorry about it. Nirodha, before answering the question, I must say that there are certain questions put forward to the panel by the members, by the viewers. So we have to answer those questions also. So I will be going through the salient features in point form so that to save time. Firstly, I see with the proposed amendments, we have introduced a practical training of 1 year under a senior before a notary takes oath as a notary. Then item number 2 is requirement of submitting an affidavit at the annual renewal of warrant confirming that he has submitted the duplicates in time during the past year. That's one of the new features. The third is requirement of obtaining an affidavit when an attorney is signing on behalf of a principal in dealing with the transfer or mortgage or whatever it is. Then fourthly, imposing the obligation of paying stamp duty on the notary with proof of payment on all 3 copies of the deed. This is done practically. This is practiced widely, but this will become law once the bill is passed. Fifthly, requirement of obtaining extracts previously when dealing with immovable property. This is one of the features introduced in the amendment. Then abolition of the requirement of submitting weekly lists. Item number 7, the 7th amendment is requirement of attaching a certified copy of the power of attorney with the original, duplicate and the protocol. Then enhancing the fines for violating provisions of the notary, by the notary. Also requiring details of notary to be incorporated in the deed, such as full name, the code number sign, address of his phone number, and details of parties, affixing a photograph to the original. These are the new features which have been introduced in the new amendment. And also, finally, the registration has become mandatory. Within 1 month, you have to register a deed. That has become mandatory. So I think Nirodha, we have to go through the questions. There are 7 questions which are put forward to us. So you can go through the questions.
Thank you very much, sir. There are a few questions that have been posted. One is that I would like to pose this question to Arupragasam sir. The first one, will the corresponding amendment be made in the registration of documents ordinance to make the registration of deeds mandatory?
Yeah, I think the Phoenician answered that question because it is section 30 subparagraph A Nirodha. It says very clearly, it shall be the duty of every notary submit for registration to the registrar every deed or instrument attested by him before the expiry of the 30 days from the date of the attestation, provided that where such deed or instrument is required to be registered outside the jurisdiction which he is practicing, he shall submit such deed or instrument for registration before the expiry of 60 days. Then also in computing the 60 days, Sundays and public holidays are excluded. Now come back to this matter, Nirodha, I think Shiranti as well as Phoenician both dealt with that issue in detail. The fact is, up to now, the law prevailed. It was not mandatory. It's only give the priority, nothing else. But the question, because it's only although it's a priority, the factual position is when it comes to a question of litigation, maybe lease agreement or any other document of that nature. If you take PFO section 2, prevention of fraud ordinance section 2, if a document is not a notarial, not duly registered, it defeats the purpose of the priority. So that is the very reason that he was a part of our team. You could remember we dealt in the issue in detail. And also at some occasion where they do the document hold back, because back again, there are certain complaints against notaries from recent past saying that I did execute this deed, I have not collected up to now, 7 months have gone, 8 months have gone. So that is the very reason now it has become mandatory. It's not only priority, it is mandatory. It says it shall, in terms of section 30, subparagraph A1, if it's the area where the notary is practicing, it is within 30 days. If it's outside the jurisdiction of the notary, it is 60 days. It is now mandatory.
Thank you very much, sir. Madam, the next question is that if the attestation states that no consideration was paid, can we rely on the phrase vendor admits and acknowledges receipt of consideration mentioned in the body of the deed? Madam, over to you.
Now, in this notaries ordinance, if you look at the new notaries amendments, we have clearly set out how the attestation should come in. And the attestation is clearly stated we cannot now, we have not only look at the notice ordinance, we have to look at the money laundering act. Because there are certain every those days almost every year they used to put a publication to say who are the people who are liable under the money laundering act. We were also one of them. The lawyer, the notaries. Therefore, we just cannot say it was acknowledged. We will have to, Mr. Kashyap also correctly pointed out, the consequence we have to specifically mention how it has passed, or if it has been acknowledged to have passed before you, I think still you also have as a notary, you have a duty to protect yourself from the Money Laundering Act, to get an acknowledgement from both of them saying, I know if they say they have exchanged the monies and it is and they certified and they are and annex that to the attestation, because especially this attestation has more clarity and it has got more detail. Now it says very well. So if you go through that, you understand. You can't just bluff your way through. You have to specifically mention how the consideration has passed. Thank you.
Mr. Felicia Fernandez, sir, I think this
Yes.
question says, can you please suggest the need for a buyer to sign the deed of transfer so that the signature can be identified in the following transactions? I think we have.
Yeah, that's a very good suggestion. I think Mr. Avulprakasam will agree with me that if the buyer also signs the deed of gift, or the deed of transfer, like in the title registration, like in the title registration, that can eliminate a lot of frauds.
If my recollection is correct, Felician, in fact, we suggested that one of our proposal is not here.
Yeah,
We did suggest.
that's a good suggestion.
Yeah.
Yeah, thank you, sir. So, Arul Pragasam, sir, the next question is pursuant to new section 31A1, is it mandatory for a notary to register a deed within 30 days of execution? What if the executant does not wish to register the same?
So the question is when because you see, I know very well as a practitioner, there are instances where we do lease agreement. When they do the lease agreement, they say it categorized into two. Rental, one, second thing to the furniture and fittings. So very often notaries, the clients request us, sir, only register the first deed in regard to the real lease value, don't register the second document. So the fact is that, in fact, at the request of the client, to date that we have done. But the fact is that now it has been mandated. If you look at the section, it says he shall be the duty of every notary to submit. Now, say for example, as I said there, so if we do not register the second part of the document, having done a lease agreement, pertaining to the payment of lease, yes, it is registered. Pertaining to the furniture, fixtures, and fitting, we don't register. And thereby what happened? That particular portion of money or the revenue that this person collects, the lessor, is defrauding the revenue, not paying the real amount. Now, I don't think we could do as notaries. We should not encourage. We must tell our clients it is now mandatory. It has to be registered. Otherwise, we are violating the law.
Thank you very much, sir. Felician, sir, is it mandatory to register? Madam Shiranti Gunawardhan, I think I have to. Is it mandatory to register a power of attorney? Madam?
Very good question, Nirodha. Generally, under the current laws, registration of power of attorney is not mandatory. But banks and financial institutions insist that a power of attorney has to be registered. Because once a power of attorney is registered, it becomes a public document also. Otherwise, especially when there are power of attorneys that come from foreign powers of attorneys, if it is not registered in Sri Lanka, it does not become a public document. Therefore, I think, in my opinion, the power of it's mandatory to register the power of attorney.
Thank you, madam. Mr. Fernando Villas, sir, On the question regarding rectification posed by a member earlier, if the rectification is regarding an error in the registration reference of the land in the deed, can the notary execute a deed of rectification instead of the ownership?
I don't think the notary can only attest a deed. He can't execute a deed. He can't be a party to a deed. He is only attesting a deed. So either the seller, if there's an error with regard to the registration number or some error, there are two ways of doing it: either rectifying it by the vendor or the buyer, or by collecting giving a request letter to the relevant land station, making alterations in the duplicate as well as in the original and in the protocol. Those are the two ways of correcting it. Other than that, I don't think the notary can execute a deed.
Thank you, sir. We are getting a lot of questions, so I'm trying to confine those questions which is relevant to the particular area which we are discussing today. This would be the last question. I will post this question to Arul Pragasam sir because he has already discussed this area. So when we put a later date in the attestation after settling stamp duty, which date should be the correct date when we put in the monthly list?
Yeah. So the important thing is, Nirodha, in the monthly list that you put the date of the execution. So the date of the execution is the first date. The second date is coming only for the purpose of the payment of the stamp duty. So for all purposes, the date will be the day of the execution, because the second day is the payment of the stamp duty. Just to add a little further what Shiranti said there about the mandatory about the power of attorney, I think you also aware, Nirodha, we have done the amendment to the this power of attorney ordinance 2. That too is now going to be a law very soon. In that, we have made it mandatory for the registration of the power of attorney, whether it's local or foreign, both.
Thank you very much, sir. So as I told earlier, we are getting a lot of questions, but due to the time constraint, I'm compelled to conclude the session, the webinar. So I would like to thank Mr. Salient Piris, President's Council, President of Bar Association of Sri Lanka, for his guidance. Mr. Isurubala Patapandi, Secretary of Bar Association of Sri Lanka, and who is heading the seminar committee. And my appreciation should go on to the committee members, Ms. Nikini Mapitigama, Pandula Vanyarachi, Dilhara Jayasekara, Adisha Disanayaka, Divya Atputanathan, and Vasinduni Fernando. Thank you very much, ladies, for all your effort in organizing this useful session. I also take this opportunity to thank our resource persons who have participated today to share their knowledge with us despite their busy schedules. Ladies and gentlemen, thank you for your patience listening. Good night and stay safe.
Thank you so much, Nirodha Madam. Once again, I will also thank on behalf of the Bar Association and the Seminars Committee. So thank you, Madam Shiranti. Thank you, Arul Prakasam sir, and thank you, Felician sir, and moderator for the day. Thank you so much, Nirodha Madam, for this very informative and valuable session. So I would also like to thank all of you who joined us through Zoom and YouTube, and for your questions that have made this webinar an interesting one. Sorry, we missed some of the questions. And also, thank you everyone. Join us again next week on Saturday for the 5th webinar in this series on